Good evening, ladies and gentlemen. How is everyone doing? How is everyone doing this evening? Thank you so much, guys, for being here. Thank you for your patience. I was trying to make sure everybody got in and we're ready to go. We won't be long. We're gonna try to make it as short as possible, but we're doing a reenactment of the 2008 trial, and we're on June 3rd, 2008, and we have a couple of people that are coming to testify in this 2008 case. I believe Lisa Van Allen is also continuing her testimony. We have lots of people that's being. I'm going to play a couple of parts today. So, without further ado, here are my cast. We have the judge. Hello, judge. How are you?
Hello. Hello.
Hi. Our first person that's being interviewed, examine and cross-examine, is Mr. Earman. Mr. Earman, hello, how are you?
Hello, blessings, everybody.
All right, Mr. Earman. And also we're gonna have Mr. Martin. Mr. Martin is one of the attorneys on Mr. Kelly's stand defense team. Hey, Mr. Martin.
Hello.
All right, we have Mr. Dunn. Mr. Dunn, I believe, is also part of Mr. Kelly's camp. I'm not too sure, but I think he is. All right, hey, hello, Mr. Dunn.
Hello.
All right, we have Mr. Jensen. Of course, you guys know you're very familiar with Mr. Jensen. He's also part of Mr. Kelly's team.
Hey.
All right, last but not least, you know Mr. Sam Adams Sr. Hello, Mr. Sam Adams Sr. How are you?
Hello.
All right, let's get started. Let's roll. All right, I'm going to call the court to order. My State of Illinois, County of Cook County, in the Circuit of Cook County, County Department, Criminal Division. It's the people of the state of Illinois, plaintiff versus Robert Kelly, defendant. Case number is 02CR 14952-1. And the recording of proceeding occurred on June 3rd, 2008 AD. We'll have appearance from the Honorable Richard Devine, which he is the state attorney. We're going to have Shauna Boyker, which is part of the state attorneys, and Mr. Robert Hellengoder, and Mr. Jensen, Mr. Mark, Mr. Adams Sr., and Adams Jr. All right. All rise. Let's begin.
Court is back in session. Please remain seated. Call the case.
Mr. Kelly, Robert Kelly.
Good morning, Your Honor.
Good afternoon, Your Honor.
Mr. Martin, this is your subpoena.
Yes.
Gentlemen, approach. Did you bring your client in?
No, Your Honor. I haven't reached my client.
All right. Mr. Genson, he can't be telling him one thing and you telling him another. Mr. Martin waved him to come up here.
Oh, he did. I didn't see that.
Well, pay attention.
I was paying attention to you, Judge.
No, you weren't, because I was watching Mr. Martin. You used to be good at this deception, but you're not good anymore. All right, Mr. Martin?
Your Honor, we were.
No. This ain't AD here. Stop it.
Just trying to help.
Get him a scooter then. That's authorized. Go ahead.
I guess I should start with the history. On May the 2nd, 2008, Mr. Genson had a conversation with Mr. Cook, which he will proffer to the court, in which Mr. Cook agreed to accept service of a subpoena testifying for James DeRogatis.
Could you identify who Mr. Cook is? I don't want everybody. We're going to do this in an orderly process. Why wouldn't Mr. Martin know who Mr. Cook was? Who is going to present this?
I'll present it, Judge. Pursuant to the conversation, our investigator,
Again, who is Mr. Cook?
Mr. Cook, is the editor-in-chief of the Chicago Sun-Times.
Go on now.
Mr. Dunn, you're aware of Mr. Cook?
Yes, I know what position he holds with the Chicago Sun-Times.
Thank you.
Pursuant to that conversation, we commissioned our investigator, John Ehrman, who is present in court standing to my right, a former Chicago police officer and now private investigator, to serve a subpoena on the Sun-Times. And in fact, I have a copy of the subpoena. Mr. Ehrman is here to attest that he served that subpoena and the circumstances of their service. I will tender the subpoena to the court.
Did you show Mr. Dunn a copy of this? Okay. Swear Mr. Ehrman. Authenticate the subpoena. John Ehrman, called as a witness on behalf of the defense, having been first duly sworn of oath, was examined and testified as follows.
One second. Someone has background noise. Mr. Ehrman.
Hold on one moment.
Thank you. Sorry, Judge.
You're welcome.
You ready?
Yes.
Sir, will you please tell us your name?
Is it still there? John Ehrman,
What do you do for a living?
private investigator.
I'm going to show you what I'll mark as Defendant Kelly's Exhibit Number 1. Have you seen a copy of that?
Well, I haven't seen the back before.
Do you recognize Defendant's Exhibit Number 1?
Yes.
What is Defendant's Exhibit Number 1?
Subpoena.
Who is it directed to?
Hold on, I lost my place. Mr. DeRogatis, James DeRogatis.
Who instructed you to serve this subpoena?
Mr. Jensen.
What date did you receive those instructions?
It might have been just prior to May 2nd. I served it on May 2nd.
Can you tell us what you did to serve the subpoena?
Where is the Sun-Times building located at? Oh, I went to the Sun-Times building.
Where is the Sun-Times building located at?
350 North New Orleans.
What did you do when you arrived there?
I went to the Sun-Times office.
Did you get up into the office?
Yes.
Tell us what happened when you got up into the offices.
There's a security desk right when you arrived, blocked off, and I approached the security guard. I told him I was there to serve a subpoena to Mr. Cook's secretary, and he then called her, and she came out and took the subpoena and walked off.
Did you, in fact, sign the back of Defendant's Exhibit Number 1?
Yes.
Acknowledging your service of that subpoena?
Yes.
That, in fact, is your signature.
Yes.
That's it with respect to Mr. Ehrman.
Mr. Dunn, do you have any questions?
Oh, I don't even know why.
Line 16.
Sir, you didn't serve the subpoena on Mr. DeRogatis, did you?
No, I didn't.
You didn't go to his home, did you?
No, I did not.
You didn't put it in a certified mail to him, did you?
No, I did not.
And you did not tender him a witness fee check, did you?
No, I did not.
That's not necessary in criminal cases, all right?
Your Honor, to complete the record, I then received a letter from Mr. Dunn, who now stands to my right, in which he represented himself to be Mr. DeRogatis' attorney and indicated that the Sun-Times had referred him a copy of the subpoena issued on behalf of the defendant and directed to James DeRogatis. That letter has previously been made part of a filing to Mr. Dunn. His last written filing in this case responded to our offer of proof. It was attached, I believe, as Exhibit D, but I will mark this as Exhibit number 2.
Your Honor, I will only object to the representation that this states that I am representing Mr. DeRogatis.
You're not representing Mr. DeRogatis?
Well, at the time I wrote that, the subpoena was arrived at the Chicago Sun-Times.
You're an officer of this court? If you're not representing Mr. DeRogatis, what are you doing here?
That subpoena.
Listen to me. I'm not even touching that. Do you represent Mr. DeRogatis?
Today I do, May 2nd.
Today is the only day you did.
No, I represented Mr. DeRogatis when we were served with the motion for a second set of subpoenas. This subpoena on May 2nd was sent to the Sun-Times, and I responded, and I had in the previous subpoena.
Well, what right do you have to respond if you're not hired by the Sun-Times?
Well, I was at the time.
Your Honor, we have been in court on a series of other motions relating to sealing, and we raised the issue of the subpoena to Mr. DeRogatis. In response to colloquy before the court prior to trial, we had filed on May the 19th defendant's motion for leave to issue subpoenas to reporters. Attached to that motion were 2 additional subpoenas with the return date of today at 11 a.m. I would ask leave to mark that as defendant Kelly's exhibit number 3 and tender that to the court.
Let me see that.
In response to that filing, Your Honor, Mr. Dunn himself appeared in court and represented it that he represented Mr. DeRogatis. We had arguments on that motion. It was, I think, 2 weeks ago, last Friday. Subsequent to that, we filed an offer of proof on May the 27th, 2008, and Mr. Dunn, in fact, filed a response to that offer of proof, which is part of the court file. We appeared before Your Honor on May the 30th, 2008. Again, Mr. Dunn appearing as Mr. DeRogatis' lawyer. At that time, Mr. Dunn acknowledged, and the court acknowledged, that his pleadings were in the nature of a motion to squash subpoena. There were arguments before the court.
Well, what day was that now?
That was May the 30th.
May 30th. What is on page 3 or page 2 of the transcript?
I just want to read what the court stated. So it's clear I am issuing the subpoenas on Mr. DeRogatis and also the subpoena Deuces Techum. Then on page 43, line 12, so the motion to squash the subpoena for Mr. DeRogatis' personal appearance is denied. The motion to squash the subpoena Deuces Techum is allowed in part and denied in part. And again, those were the subpoenas which we attached to our original motions with the return date of today at 11 o'clock.
All right, Mr. Dunn.
Mr. Dunn.
I'm sorry, I muted myself. Okay. Your Honor, we are not sure what this hearing was called for. I received no notice that there was going to be a hearing.
Well, it's called for whether I'm going to issue a warrant for the rest of your client. That's one of the things. All right. So go ahead.
I would object to the deficiency in the notice then of the hearing.
That's fine. What are you claiming about notice? You better start understanding procedures in this. What notice are you claiming you're entitled to?
Notice of this hearing.
All right. What is the cause of this hearing?
Apparently, although I see no orders to that effect, statements were made that either I or Mr. DeRogatis should be here today. Actually, I've had 2 different statements.
Mr. Dunn, you have consistently not ordered transcripts. Did you order the transcript for May 30th?
In fact,
Counsel, please.
yes.
Do you have it with you?
No, I don't have it with me.
All right.
We filed a notice of appeal this morning.
Did it say on page 2, as Mr. Martin had read, that the subpoena issued for Mr. DeRogatis and also the subpoena ducis tecum issued for Mr. DeRogatis?
Where?
Point it out to him, please.
It's page 3, line 3.
Mr. Dunn, read it out loud so we all know what you're reading, so there's no doubt in my mind.
So it's clear I am issuing the subpoena on Mr. DeRogatis and also the subpoena ducis tecum.
You were authorized to represent him on that date. Is that correct?
Yes, I was.
So notice to you is notice to your client, right?
Depending on what the notice is, I have notice of this, I suppose.
Well, then notice is the subpoena, Mr. Dunn. All right? Do you understand? What are you appealing right now?
We are appealing this, not this transcript, but we are appealing the order that we entered yesterday by this court.
What order? The written order?
As I recall, Your Honor closed this by saying you were going to issue a written order. So we waited for the written order to be issued. As soon as we got the written order, we filed a notice of appeal pursuant to the reporter's privilege status.
Okay. The reporter's privilege. What does the law say about the reporter's privilege while on appeal?
The law says that the reporter's privilege remains in effect for the pendency of the appeal, and no contempt can be held against the reporter until everything is final.
Show me that, where it says no contempt could be held against a reporter. I think you're making a little bit of Illinois' law up today.
If I had more notice, I would have brought a copy.
Counsel, you're the one quoting this thing. They hired you to be the expert in this area. You have notice when you accepted employment.
I can cite you the section, Your Honor.
You read me the law where it says he can't be held in contempt, as you say. You misrepresented to this court before.
I take issue with that, Your Honor.
Well, you should. And I take issue with it too, counsel. Counsel, to refresh your recollection, you said that the people of the state of Illinois versus Congressman Mel Reynolds was not the law. It is the law, all right? I'm not going to go through a litany of other things that you said here.
The statutory section is 735 ILCS 58909, and it says essentially that.
Read it.
I don't have it with me, Your Honor. What I do have here, Your Honor, my understanding is that when you file a notice of appeal, the privilege remains in effect until the appellate court rules.
But what privilege are you talking about now? So we can all have common terms.
Reporter's privilege.
What does that cover?
That covers everything that your order required. Mr. DeRogatis too.
You're talking nonsense. And I hate to use those words. It protects the privilege. Where in God's name do you see that this thing says it covers everything? You know, you're reading these things and you're not really quoting the law. All right? I'm going to recess this, and you better get something by 12:15. Court is in recess until 12:15.
Your Honor, we have a non-party, James DeRogatis, motion for entry of an order formally staying the order dated June 2nd, 2008.
Did you enter the order, or did the appellate court enter the order?
No, this is a motion, Your Honor. It is my understanding I need to present this motion to you.
Focus. You've quoted a lot of law here today, and I want to see some of the representation in writing by the Illinois state legislator that a reporter cannot be held in contempt because of the reporter privilege. When Mr. Martin has pleaded 7 times saying this has nothing to do with the privilege. Mr. Martin, so the record is clear, you want to know the source of people's number 1, which is the tape in question.
No, Your Honor. We've indicated every question we intend to ask Mr. DeRogatis. The court has ruled on these questions.
All right. 12:15. Give me the law. Mr. Dunn, as you interpret it.
Robert Kelly.
Mr. Dunn, did you find the law that you said that no reporter could be held in contempt?
I'll tender it to the court.
Articulate it out loud.
All right. I'll read the 2 statutory provisions in conjunction of 735 ILCS 5/8. The first is section 8-908. Privilege continues during pendency of appeal. In case of an appeal, the privilege conferred by Part 9 of Article, what's that? V11, I think that's 5. What's that? 8 of Section Act remains in full force and effects during the pendency of such appeal.
Okay. Can we just stop here? Is anybody in disagreement with that?
No, Your Honor.
All right. That's fine. But the privilege is the source or information leading to the source. It isn't the other information. Go ahead and read the other section.
8-909, immediately afterwards, contempt. A person refusing to testify or otherwise comply with the order to disclose the source of the information as specified in such order, after such order becomes final, may be adjudged in contempt of the court and punished accordingly.
Certainly. That's not our wish here. But the thing is, you said nobody could be held in contempt. This gives a provision where somebody could be held in contempt. What is the docket number that you got from the appellate court when you filed today?
Did we get a docket number?
Not yet. We filed it and they're sending it over here. We filed it over at the Daily Center. They're sending it over here. So we have not assigned a docket number yet, just yet.
Mr. Adam, you filed an appeal in this case?
Yes, I did.
When you file the appeal, do they give you a docket question number right away?
You have to go to the appellate court. They gave you a docket number right away. Yes.
When you file it?
Yes.
Well, we filed a notice first with the circuit court to advise them of our seeking of appeal, and we are going to take the notice over to the appellate court.
It's not in the Civic Center. It's at what is now called the Bellandic building.
Over at Randolph and LaSalle, right?
Right. But you get your docket number from the appellate court.
Oh, did I read that
Read the wrong
already.
thing, but that's okay.
Sorry. We filed the notice first with the circuit court and advised them of our seeking of appeal, and we're going to take the notice over to the appellate court.
But the notice, let me explain. The notice has to be filed in the appellate court. It's a notice of appeal to the appellate court, not to the circuit court or trial court. So you only filed it at the Daily Center.
Thus far, Your Honor, yes.
What do you mean, thus far? I'm asking you a simple question. You know, you guys are complicating a lot. You filed in the wrong court. If you're going to file a notice of appeal, it has to be filed in the appellate court, not in the trial court. So there is nothing pending in the appellate court. That's why I asked you for the docket number. If you filed an appeal or notice of appeal in the appellate court, they give you a docket number immediately. Is that correct, Mr. Adams?
When I filed the appeal,
You were just up there 3 weeks ago.
yes, In fact, they wouldn't take it until you bring them over the documents and they stamp it right there and you give you a number.
So you didn't appear in the appellate court at all.
Not yet, Your Honor.
What is the matter with just no? What do you mean, not yet? So there is nothing pending.
The appeal, once it's filed in the circuit court, Your Honor.
You don't file the appeal in the circuit court.
You file a notice of appeal in the circuit court and then take the notice over to the appellate court and get a docket number.
All right. Ms. Ocala, come over here and identify yourself. Ms. Ocala, could you state your name and spell your last name for the record?
Wait a minute, I think you went to the wrong spot.
You want me to take that?
I'll take it. I don't think there's any Yeah, I'll take it. Robin Socalo. Robin.
And what's your position?
Manager of the court clerk and the clerk of the circuit court.
How long have you worked for the clerk of the circuit court?
17 years.
How many years as a supervisor?
10.
You've heard counsel say that you filed notice of appeal in the circuit court. Is your experience as a supervisor and also as a clerk, is that the correct procedure?
No.
All right, thank you.
You're welcome.
Also, I'm sorry.
Also, Your Honor, we tender People versus Slover, Slover, Slover.
Slover interpreted Palacio, and that just means that it's basically the same language again. The source can't be disclosed unless there is a divestiture of information leading to the source. What was this about? No, this wasn't about that. There's another district court that came after that case that you're citing, which interpreted. Is Pfizer was suing. I think it's JAMA or the American Medical Association. They had written an article and they wanted the peer review notes and they limited the interpretation of Slover. But Slover, again, is what we have at the heart right here, is that no source, no information leading to the source. It doesn't have to be verbal testimony. It could be an exhibit. Mr. Martin has said about 15 times right now, he doesn't want to go to the source. I've made it my order that he's not going to go to the source. I will not allow him to do that. So you're protecting something that nobody is after.
Your Honor, we disagree with Mr. Martin's interpretation of the source. You can call a camel a horse. It doesn't make it a horse.
Well, let's get the facts straight here. Mr. Martin, give me the facts how Mr. DeRogatis is involved in this case.
Your Honor, Mr. DeRogatis is a reporter for the Chicago Sun-Times. In December of 2000,
State, I want you up here. You're going to be answering some questions too. Go ahead.
In December of 2000, he was the author of articles critical of Mr. Kelly. He has written a series of articles critical.
That's not material and relevant here. I don't care. Let's go.
The testimony based on his record is that in early February of 2002, People's Exhibit number 1 anonymously appeared in his mailbox. He is represented in his articles.
And you don't want to go into that, and you're not going to be allowed to. Is that correct?
Right. And he doesn't know the source, so there's nothing to ask him.
Well, that's not that simple. Even if he says, he could have been editorializing or protecting the source, even if he says that it was anonymous, you can't go into that area.
Okay. The questions we want to ask are set forth in our offer of proof.
Just briefly, I'm fairly familiar with your offer of proof. State, where did you get People's number 1 from?
We received it from Everett.
Where did he get it from?
From Mr. DeRogatis.
So this is the tape that is the subject of this whole prosecution.
Correct.
And the source of that, not in the editorial or reporter privilege meaning, was Mr. DeRogatis.
Correct.
Go ahead, Mr. Martin.
That's my understanding. There's an issue of when that was provided to Mr. Everett. Mr. Everett has testified it was provided on February the 1st, 2002. Yet, Mr. DeRogatis and Miss Stephanie Edwards testified, and DeRogatis.
No, you're meshing all the watercolors in one bowl and throwing water on there.
Ms. Edwards testified that on February the 4th, 2002, she viewed that tape with Mr. DeRogatis in his office.
And the testimony by the investigator Everett, who is retired, was he received it February the 1st.
February the 1st.
So then it implies that it was either a copy or an additional piece of information, well, additional tape or DVD of People's Number One. Is that correct?
Yes, Your Honor.
These are not reporter privilege things. He's a material witness to a crime, all right? That's how this whole prosecution got started. State, would you have been able to go forward if there was never a tape?
Of course not.
Go ahead.
Based on Stephanie Edwards' testimony in her transcript at pages 23, 24, 94, and 95, she testified, as just mentioned, that she had met Mr. DeRogatis in his office and viewed a copy of People's Number One, and then she went and met with investigator Everett that same day. That's what we are seeking to question Mr. DeRogatis about. We're not asking him where he got the videotape, what the source of the videotape was.
Mr. Martin, I'm sorry for interrupting, but have you ever filed a legal complaint for divestiture of the reporter privilege?
No, we have not.
And certainly you would be doing your client a disservice if you filed a complaint for divestiture of his privilege. Isn't that correct, Mr. Dunn?
I certainly would.
Right. So divestiture is not at issue here.
Your Honor, we take issue with that very strongly. We believe that this is exactly how it played out in the Slover case, where the judge went ahead and said there wasn't a privilege. A rule to show cause motion was filed, which hasn't been filed here. They had a hearing. The reporter asked that he be sentenced to contempt, so they picked it up. The appellate court looked at it and said, we are not following Placio anymore.
You know, you quote these things. Remember, you told me that Shepard wasn't followed anymore, and that was overturned by another court case. And that didn't turn out to be the facts either.
I'll stand by that statement.
Fine. It says, Mr. Dunn argued that Shepard is no longer viable. Transcripts at page 34 on May 8, 2008, and implied it had been overturned by Press Enterprise. This court has found nothing to indicate that any points of law articulated in Shepard and relied upon by the parties have been overturned. So do you got Slover with you?
Yes, I do.
Tell me where it overturns Palacio in their words, not your interpretation.
All right, I'll go right to the dissent.
To the dissent?
Yes.
How's the dissent the majority opinion?
Because the dissent says the majority now abandons the holding in Palacio that the reporter's privilege is limited in favor of a board holding whenever a litigant seeks to a photograph from a newspaper.
What legal effect does the dissent have?
I think the dissent basically interprets the majority's opinion as abandoning Palacio.
Wouldn't the majority interpreting their own opinion have more weight?
Yes, and they said we wrote the legislature did not limit the scope of the section 8-901 of the code by inserting either the name or the identity of before the source of any information. In this case, defendants desire certain information, namely whether police dumped burn barrels during searching prior to March 10, 1998, when defendants subpoenaed the Herald's photographs and filed their motion for a rule to show cause. They sought to compel respondents to disclose a source of that information. When the trial court found the statutory reporter's privilege did not apply, it erred as a matter of law. Accordingly, we reversed the trial court's order compelling respondents to produce unpublished photographs, and we reversed the contempt filing based upon Bellows' violation of that order. We remand that the trial court to allow defendants to file an application to divest the privilege pursuant to section 8-903A of the code if they are desired.
Did you hear your words? Did you hear your words though? The unpublished photographs. Who are seeking any information that are unpublished here?
The subpoena due TechCom asked for unpublished interview notes.
After February 1st, 2002. All right. Go ahead, Mr. Martin.
Your Honor, I think we have shown that Mr. Kelly has a right to present a defense. How DeRogatis' testimony is material, how People's Exhibit 1 is a causation by the police authorities and ultimately to Cook County State's Attorney's Office are facts that are at issue in this case, and therefore we want to call Mr. DeRogatis on those facts. Your Honor, I was here last Friday, May the 30th. The court issued an order from the bench that the subpoenas attached to our offer of proof issued. Those subpoenas were dated for today. Mr. Dunn has always been here as a lawyer for Mr. DeRogatis and has acted as his agent in that regard. Mr. DeRogatis is not here. I respectfully submit, even if the notice of appeal was on file and there was a docket number, that would only stay surrender to privilege. We are not seeking privileged information here. Mr. DeRogatis is not above the law. There has been a court-ordered subpoena that has issued. There is previous service of this subpoena as well. But I think it's the court-ordered subpoenas that apply here. And we would only ask that a rule to show cause issue and that Mr. DeRogatis be ordered to appear.
Mr. Dunn?
We take issue with that subpoena, that with any subpoenas that have been served on Mr. DeRogatis, as this court, I think, has consistently made clear.
Mr. Dunn, I just don't understand you. Read page 3, Mr. Martin, of the transcripts from May 30th.
May 30th, 2008, the court. So it's clear I am issuing the subpoena on Mr. DeRogatis and also the subpoena Deuce Techum.
If you represent Mr. DeRogatis, you're certainly his agent for service, Mr. Dunn. Are you saying that you don't?
No one has served me with anything either. We just had a special process server up here testifying about service.
No. We're talking about Friday, May the 30th. You've had copies of the application and other things in your hand and subpoenas. Here's what I'm going to do.
Your Honor, I'm sorry.
Go ahead. Proceed.
Your Honor, just labeling information a source does not remove it from the statutory privilege. We have asserted that the information does involve source material. They have asserted to the contrary. Your Honor has sided with them. The statutory makes very clear, however, that we are entitled, once we have made the assertion, to test that assertion on appeal, which is what we're doing. There will be no point to those two provisions in the statute if it were not to hold this question in abeyance until the appellate court can rule. The statute is very different from the federal system. There is no Judy Miller statute in Illinois courts. It's very different from most other statutes. We are unique in incorporating this additional protection for reporters. And so far as I know, therefore, we believe that the stay, regardless, actually, we believe that the stay is in effect even if we don't file notice of appeal for 30 days. But we are not desirous of holding anything up in this court. We have been inviting divestiture application for 2 years. We filed our notice. We filed our notice the very next morning, as soon as the doors opened after receiving a copy of your Honor's written opinion. When I did not receive from court or opposing counsel, I had to make effort to get a reporter to fax it to me in order to have something that I could take up to appeal.
Mr. Herman, come up here. Mr. Herman, could you state your name and spell your last name for the record?
Eric Herman, Herman.
How are you employed?
I am a reporter for the Chicago Sun-Times.
This is the same paper or the same corporation that's represented by Mr. Dunn. Is that correct?
Correct.
You're also an officer of the court. You're a lawyer.
Correct. Although I'm not in active practice, I've never been.
So you're not a member of the Illinois State Bar?
I am a member of an Illinois bar, although my CLE credits are not up to stuff.
Didn't we ask you if you could accept the order for your employer yesterday?
Yes.
Did you accept the order?
Yes.
Thank you. You can have a seat.
Your Honor.
Mr. Dunn, you never made any inquiry, called up here yesterday at all. I said that the order would be in writing, issued on Monday. That means, as you like to say, we had to work over the weekend.
Yes, Your Honor.
You never called up and asked.
Before I left, I spoke with your press liaison, and he said that as a courtesy, he would try to get me a copy. I received a message from someone in his office saying that the order had been issued. I called his office back and asked him if they could send me one.
When did you call the court? Unless we're going to bring Mr. Sullivan in. Did this occur? Get up here. You might as well. We're bringing everybody else in. State your name and spell your last name for the record.
Terry Sullivan, Sullivan.
You heard what Mr. Dunn said. Did that occur?
I did, Judge. The day before or 2 days before the court issued the order, I did state that I would
facilitate
if I could getting an order to Mr. Dunn. I did facilitate by getting, pursuant to your request, a copy to Mr. Herman, who acknowledged.
It was a duplicate original, not a copy.
Yes, it was.
So that's the way that you facilitated it?
I understand that was faxed to Mr. Dunn, but I was not at my office yesterday to do anything because I was here.
Same with Mr. Herman. He was here.
He's in constant communication with the world, counsel.
I did receive a copy at around 4 o'clock, and Mr. Rosenbaum started preparing the notice of appeal immediately.
Right, which he served on the circuit court.
Right, the way it works, Your Honor. We have 30 days to do it, and we did it almost instantaneously. We are not trying to hold anything up here.
I'm not saying that.
We have tried, we have accommodated this court. We have come down on telephone notice from opposing counsel without any kind of written papers. This was never formally served on me. It was sent to me by fax. We have done everything we can to accommodate this court. We have no desire to hold up this trial. If Mr. DeRogatis was a disgruntled fan, he would be happy to testify here. But if he testified as a reporter, it would be a serious breach of his statutory rights and his constitutional rights. That's when this morning all of this confusion, at least in my mind, regarding conflicting instructions I received from various sources arrived, and we had a notice on file. We had notice on file. I understand that maybe somebody can defer with my interpretation of the privilege, and they can defer with my interpretation as to how the appellate function works. But we've prepared a motion for entry of an order formally stating the court's order on June 2nd, 2008. We believe those grounds are well taken. I have the motion with me. I can give a copy to the court. I can tender a copy to counsel. It addresses, I think, all the meritorious reasons why a stay would be there. My understanding is in order for me to seek a stay for the appellate court, even though I don't think that anybody has ever had to seek one in this particular content, but if I want to go outside the statute and get better insurance, I would need your court to consider my motion and deny it so that I can take it up this afternoon.
Have you given anybody copies of this motion?
I just have it with me today. I tried to tender it a little bit earlier. Mr. Rosenbaum has a copy.
I have a copy.
We are at somewhat of a handicap. We'd like to be able to file down here, but it takes us something like an hour to get anything down here.
Courtesy copy.
Yes, please. Here's what I'm going to do is let you all take a look at this. I want everybody back at 1:20. That's a half an hour. Thank you.
Whereupon a recess was taken.
Mr. Dunn.
I've been on the phone with the appellate court trying to figure out what you need to do to get a docket number from them. It's a challenge to get it within 24 hours.
We'll try and remedy that. All right. Call the case.
Robert Kelly.
All right. Mr. Martin, have you had a chance to look at Mr. Dunn's motion for an entry of an order formally staying the order of June 2nd, 2008 by this trial court?
I have, Your Honor. I will be prepared to orally respond to it.
Mr. Dunn, are you ready?
I am ready.
Proceed, Mr. Dunn.
Your Honor, paragraph 1.
I'm sorry. For the purposes of this hearing, that would be Mr. Dunn. Mr. Dunn, will you proceed?
That was subtle. Your Honor, as I stated earlier today, it is the reporter's position that we do not need to seek a formal stay from this court, that the statute is self-officiating for those purposes. Nevertheless, we filed a notice for appeal. Mr. Rosenbaum has been talking with the appellate court. It appears we did everything we could do to get that done expeditiously. We then found out that there was obviously some confusion on our part as to how that order was being interpreted down here. We filed this motion for a formal order staying the case. There are two reasons for that. One, I don't need reporters to feel that the power of the state is coming down on their heads, unless the power of the state really does need to come down on their heads. But more importantly, I think that it would help to get everybody on the same page so that I'm not advising people in the dark. Therefore, without wanting to waive any of the statutory rights, we wrote this motion up today. I may have some of the facts wrong. Now that I'm down here, I'm hearing other facts. I don't think any of the facts that I may have wrong in here on the first couple of paragraphs are material. I basically wanted everyone to know our position. Our view is that in most of these cases, I don't have time to pull the research, but in most of these cases, certainly the Slover case, the stay is entered, be that as it may.
But again, in the Slover case, just so the facts are straight and the record is straight, those were unpublished photographs. And this person was a photojournalist. And the subpoena was for the unfurnished photographs. Is that correct?
Mr. Dunn, you're muted.
Correct.
Your contention is that the analogy of the subpoena, ducis tecum, will be the same because the defense wants Mr. DeRogatis' notes after February the 1st, 2002, when he had turned over People's Number One to the police, okay?
Your Honor, I think I understand where the court is coming from. And I think I can understand where the defense is coming from under the question of what is a source and what is not a source. I think the important issue is that that's a question of law which needs to be decided by the appellate court pursuant to the way the statute operates. We think that just so there is no confusion, this court should stay the order. I commit we'll do everything as we have throughout this case to expeditiously pursue this action. In fact, we filed papers on 48 hours notice just so we could appraise the court and the parties of our position and the law as we see it. As I interpret the rules this morning, we need to give Your Honor the first crack at the stay motion before we take it to the appellate court.
And I appreciate that courtesy. Thank you.
Therefore, we have filed this motion. We think that the law cited in the motion was with respect to the Slover case with the Willis's case show that we are not filing this motion to delay. We're not filing it in bad faith. We're filing it because we believe solid law in our corner. Finally, we suggest that the equities would support the stay. It is not Mr. DeRogatis that has brought up to this point in this time compression. In 2006, we tried to kickstart this thing, but as Your Honor pointed out, I would be committing malpractice in 2006. I had to come into this court and file a motion to divest. I have to work with that, with what the rule gives me. I don't mean disrespect to the court to defend it to anyone in this case, but I have to do what I believe is right for my client within the bounds of the law. I had some questions whether I should either file this motion or whether I should, look for some other form of relief. But I think in fairness to everyone, we'll put our cards on the table.
Mr. Dunn, I appreciate that. Thank you. Mr. Martin?
Your Honor, I can only respond to what's before me in writing. In paragraph 1, the respondent states he was never served with subpoenas to compel his appearance or subpoenas for the production of interview notes. We will respectfully disagree. In paragraph 2, he states the respondent is unaware whether an actual order requiring his appearance on today's date has been entered and that no such order was served upon the respondent or his counsel. Well, we've read into the record about 4 or 5 times the court's order of last Friday in which he granted the motion to issue subpoenas. The actual written subpoenas were attached to the pleading, which was served on counsel. There's no question about that. The subpoenas had a return date of today, June the 3rd. So there has been service, and I don't know how Mr. Dunn can say he was unaware of the subpoenas. They were attached to the motion, and the court orally entered their order. I feel like we're going around in circles and trying to relitigate what we argued last week and what the court entered a written ruling on yesterday. And that is, what is the scope of privilege? I agree that the statute states that the privilege remains.
Let me just clarify this. Are you calling Mr. DeRogatis as a reporter, or are you calling him as a material witness that turned over People's Exhibit number 1, which is the basis of this prosecution?
We're calling him as a material witness who turned over People's Exhibit number 1, which is the basis of the prosecution.
Thank you.
We've been arguing for some time now whether we are seeking privileged information, and the court has made rulings in that regard, and we've made representations in that regard, and the statutory stay only applies to the privilege. Mr. DeRogatis, I don't know what his excuse is for not appearing today. His counsel was in court last.
I'm going to give him the benefit of the doubt. There could be some confusion.
Give him the benefit of the doubt. We would ask that he be ordered to appear here tomorrow so we could call him as a material witness in our case. Again, Mr. Kelly has constitutional rights that are at stake here that need to be considered. Your Honor, I'm not going to repeat all the arguments we've made before. I think the court understands the scope of the privilege that's limited in nature. It doesn't give a reporter with an excuse to ignore a subpoena. We've talked about the Slover case, Your Honor. Slover case was unpublished material of a reporter who was reporting the case, not somebody who tendered over the critical piece of evidence in the case. It's factually distinguishable and it's legally distinguishable. I could go on about this. The respondent cites People versus Willis, but in Willis, they talk about the special witness doctrine has been applied to reporters who in no way participated in the case in which they testified, in which the defendant was trying to call the reporter as a reporter. We're not trying to do that, Your Honor. Mr. DeRogatis was a person who produced People's Exhibit number 1 to the police. There has been testimony about this. That's what we're seeking to call him, to effect our constitutional right to present a defense. Again, we ask Your Honor to deny the stay motion. Order Mr. DeRogatis to appear here tomorrow. If he wants to get on the stand and assert some other privilege, then we can deal with that. But the privilege has to come from him, and we'd ask again that the subpoenas reissue and that he appear here tomorrow.
Thank you. Mr. Dunn?
I only want to comment on the material witness question. I feel like I'm getting sided because my understanding was he wasn't going to testify no matter what happened today with respect to the acquisition of People's number 1, but he was going to testify as an event that happened after he received it, interviewing a witness after he turned over People's 1. So it seems to me it's clearly calling for a reporter's testimony.
I could see where there would be some confusion, but let Mr. Martin clarify.
Your Honor, there are really 2 critical facts that we seek to call him on. One is the acquisition of People's number 1, his tender of that to the police. And it's not where he's kept something a secret, where he's kept something privileged, but he's actually tendered to law enforcement authorities and spoke to them about it. Number 2 is after that date, as far as it appears in the record now, he apparently has a copy of this tape, which is a crime. And he is meeting with a critical witness in this case and viewing that tape. Those are the 2 underlying events that we would question him about.
All right. Here's my ruling. First of all, this is a jury trial. People of the state of Illinois versus Robert Kelly that began on May 9th, 2008. Yesterday, the prosecution rested their case in chief on June 2nd, 2008. The defense has subpoenaed Mr. DeRogatis. I have issued the subpoenas, as I said, on May the 30th. To make it clear, those subpoenas for subpoena duces tecum and for personal appearances are in effect. The motion to quash the subpoenas was denied as far as Mr. DeRogatis was concerned. So was his personal appearance, sustained in part, denied in part, concerning the subpoena duces tecum. I'm going to add another faction to the subpoena duces tecum. As far as the notes are concerned, before they would be turned over, there would be an in-camera inspection by myself to make sure there would be no source material, no evidence leading to information concerning the source, and no documentation concerning the source itself. All right? Mr. Martin says that he happens to be calling Mr. DeRogatis as the individual that was the person that turned over People's Exhibit Number 1, which is the tape that the prosecutors have stated in open court is the basis of the prosecution. And they also stated that there would not be a case unless People Number 1 was turned over by Mr. DeRogatis. Mr. DeRogatis is being called, it is my interpretation, as a material witness and not as a reporter. He's a person that happens to be a reporter that turned over this information that started the prosecution. And nobody is saying anything is bad about that. The other thing is, I'm allowing the request by Mr. Martin to orally file a rule to show cause. And a rule to show cause will be orally issued. And I'll allow Mr. Martin to file that instanter tomorrow. As soon as you drop those documents, could you get them to Mr. Dunn, please? I'm ordering Mr. Dunn to produce his client tomorrow at 10 a.m. Both the notes that have been the order as issued on June 2nd, 2008, and have the client appear at 10 a.m. All right. These orders are valid unless the denial of your order to stay has gone up to the appellate court as an emergency motion, which you still can have adequate time to do today. And then if they issue a stay in order on my order, denying the motion to stay, then we're back at 1.
Mr. Dunn.
I'm sorry, I keep muting myself because of noise.
No, I muted you.
Oh, you muted me. Okay. What I say? I think I needed. Hold on, I said it. I think I needed that part from Your Honor that you denied the motion to stay.
Yes, the motion, so we're all clear, is denied. Again, my orders are in effect unless the appellate court, after you go up there on an emergency motion, stays my order, denying the order to stay, which is getting kind of complicated.
Your Honor, could I ask for some additional time? I think I need to send this transcript up to the appellate court as well.
Well, it's an emergency motion. Here, we're beginning defendant's case in chief. That's why I started this out by saying this trial began on May the 9th, 2008, and it's a jury trial. We've had the jury. We have 15 people in the jury box, 3 alternates and 12 jurors.
I think I need 3 judges for this. I'm not sure. I can do it with 1?
I assure you, if they want to consider it, and then you have your petition is well pled, so they'll review that. To my understanding, Mr. Adam, you're a renowned appellate court.
No, they immediately ruled that the appellate court did not have jurisdiction for my motion, and they did it within 24 to 48 hours.
Right. So you might even get a ruling this afternoon.
But 24 to 48 hours doesn't get me to 10 o'clock tomorrow.
That's why I'm making it clear that my order is in effect unless there is an appellate court staying my order.
Yes, so it's clear, Your Honor. I requested additional time.
Absolutely. Let the record reflect. And certainly Mr. Dunn has. And I understand his position. But my position is I have 15 people in the jury box. This trial has been now into its 4th week. I understand your position, but I can't do this to the jury trial and just keep that waiting. Thank you, gentlemen. That's the order.
Another matter, Judge.
Oh, Lord.
Totally different.
Go ahead.
Yesterday.
Who is involved with this? Mr. Dunn?
No, Mr. Dunn is not involved. That's why I said totally different.
Is this an ex parte thing, or can the state stand up and be part of it too?
Of course, the state is a part of it. I would not have addressed Your Honor.
Well, give them a little bit of notice.
What I'm about to say is to tell Your Honor that they do not have notice.
Okay.
I just want the record to reflect it.
All right.
Yesterday.
Your Honor, I guess you're excused then. We're excused then.
Yes, thank you. Good luck.
Yesterday, the state's witness.
Why don't we wait for counsel to clear out?
Thank you.
Take care. Safe trip downtown. All right. Give them part of the bench. Share a little.
I'll do whatever Your Honor says. Yesterday, Lisa Van Allen identified the People's Exhibit as being herself and Mr. Kelly and Lena Prado.
Yes.
I cross-examined her about Lena Prado.
Right.
I'm now telling Your Honor that Lena Prado will be a witness in this case. The state has her name, address, and her phone number. We're adding her to our list of witnesses.
When did you give the state that?
About 7 o'clock last night, Your Honor.
We gave them the phone number in court.
What time?
Right when you told us to.
Well, it isn't a difficult question. I want to establish something on the record.
I wasn't looking at the clock. I look at Your Honor when Your Honor rules on something.
Mr. Martin keeps track of those things.
I think we got it. We got an address in court yesterday, Your Honor. Sometime, I don't remember when.
When you told us to. That's the answer. When you told us to do it, we did it.
I can fill in some details. I'm going to guess around 1:30, the court ordered us to provide an address. We obtained that address, and Mr. Sam Adams Jr. wrote it on a piece of paper and provided it to the state.
Well, that wasn't at 7 o'clock at night.
No, yesterday afternoon.
Was that the correct address?
It was the correct address, yes, sir.
Well, then the state was incorrect with their 7 o'clock at night.
An investigator, Mr. Ehrman, interviewed Miss Prada on the phone yesterday afternoon. We typed up a summary of that interview, and that was provided to the state last night with her phone number.
Excuse me a moment. So you disclosed the name, address, and phone number?
Just to make the record clear, yesterday, I know when we had a sidebar, Mr. Adams said that he not only said it was attorney-client privilege, I believe that the statement, in fact,
Which was?
the statement that he alleged that he never saw or never had any information from.
I don't understand the context.
When we had a sidebar yesterday, when we asked for any type of statement or anything that that this witness may say before Your Honor allowed the impeachment on the witness stand with Miss Van Allen.
Oh, you mean the other one, Mr. Pryor, we're talking about.
No, when he asked her about Miss Prado.
Does anybody have the transcript?
I do.
Then they can point out what they're saying.
All right. I'll have to look, Judge.
Okay.
Judge, what happened at the sidebar is I asked about Lena Prado. We then had the sidebar. Your Honor asked me, where did you get the information? Have you spoken to Lena Prado? Did you get a statement from her? I said, I have not spoken to her. I have no statement from her, which I did not have. You then said, well, you have to tell me where you got the information. And my answer on where I got the information about Lena Prado was the attorney-client privilege.
Your Honor, what we're stating is that the statement that we got sometime before 7 o'clock last evening was exactly the same question that Mr. Adam, in fact, asked the witness on the stand and was not certainly taken by an attorney, but was, in fact, taken by the investigator, Mr. Ehrman. Just to set the record clear, so it must have been information that he had available then. He could have written down a phone number. He could have written down an address. He certainly could have written down part and partial of what what this individual had said to his investigator or himself.
Are you saying that they had the statement of this Lena prior to cross-examination of Lisa Van Allen?
All I'm saying is that the statement mirrored the statement that we received sometime before 7. I have the facts upstairs, mirrored what the questioning was of Miss Van Allen yesterday.
Judge, I have no understanding at all of what she's saying. I'm telling you, as an officer of this court, I've never spoke to Lena. As far as a statement from...
No. If you're the only person trying this case, that's fine. Are you saying nobody on Mr. Kelly's defense team?
I can't say. I don't know what other people...
Well, then only limit it to you.
I got the information as a result of the attorney-client privilege. Up to this very moment, as I'm standing in front of you now, I haven't seen Ehrman's statement yet. Mark is the only one who's seen it. They're going to give it to me as soon as we're through here this afternoon. I just asked them to email it. Miss Boilinker said she's seen it. I haven't seen it yet, and that's the truth.
Why are you holding the statement up from him?
Yeah, why are you holding the statement up from me?
He does.
Counsel, what are you seeking?
Your Honor, it just seemed ironic that in court, around the same time that we made this objection, they were able to provide the information such as address and phone number, but they weren't able to provide a brief handwritten summary. The same information. There's nothing different about the phone number and the address that's any different than a quick 2 sentence about what the summary is. They're able to provide that.
When did Mr. Ehrman take the statement?
Yesterday afternoon.
After the cross-examination?
Yes. We recessed in the hall and we got the information the court requested. I asked him to take a statement from her at that time.
Judge, all we're doing is making a record of the fact that the statement mirrors the questioning.
He's obviously had enough knowledge to ask those impeachment questions, which now were mirrored by something that we got at 7 o'clock. The address that was provided at the time that we made the objection was given to us then. It just begs the question, why couldn't a sentence or two have been also summarized?
You have 1,000 lawyers in the state's attorney office and maybe 100 and something investigators. You couldn't call somebody up while these people were on trial and tell them to interview this Lena?
Judge, we had moments to do that at that point.
They had moments too, and they got a lot less budget than you do. Those are the things that you do, but they're not the things that you've been prohibited from doing. So here's the thing. You say that the questions, that their summary of the witness testimony or witness statement summarizes what they're going to impeach. You can bring that out too, right? On cross-examination. I don't see anything wrong here other than what you're saying, that they intentionally made you put a witness into a picture and then cross-examine on that witness that the state produced.
No, Judge. We're just saying there was some misrepresentation, if you will, made to the court in regards to the information that they had at the time of the cross-examination.
How could it be a misrepresentation? Ironman didn't even talk to the witness until either during or after my cross-examination. I didn't have a statement from this witness, and neither did anybody in the defense team have one at the time of the cross-examination. I don't know what they're talking about, misrepresentation.
Actually, we don't know that because
I'm telling you that.
He's representing. The other thing is, there are also phone records and everything else like that. It would be a stupid lie to say.
Of course it could.
Because you know there's going to be a phone call to Mr. Ehrman telling him to get over there and talk to this person or contact this witness. All right? He's not stupid, and he's also honest. So I don't think that they were sandbagging. Here's the other thing. What you're saying is people exhibit, whatever it was, that they like maneuvered you into putting her into that picture. This is your evidence, not theirs. So I don't understand it. It's not coming across clear. All right? Thank you.
Thank you, Judge. See you tomorrow.
All right. Court is in recess on this case until 11 a.m. and then our regular call also.
case continue on 6408. Ooh.
Ooh.
All right, guys, what do you think about this?
Oh my Lord.
I like him too. I like Adam.
Look at this. Look at this, y'all. Let me tell y'all something. I'm gonna play that video that he talked about with that tape. Hold on, y'all. I'm talking about DeRogatis.
I think Jim DeRogatis is fighting awful hard not to have to talk on that stand.
He
Because
sure is.
Then and now.
Yeah, I believe he's part of that tape.
Then and now.
And then he watched it with Lisa Van Allen after.
And that's a crime. That's a crime.
Yeah, that's a
At
crime.
his office. At his office.
Yep.
That's crazy. And then he tried
No,
to say,
Stephanie Edwards. Didn't they say Stephanie Edwards? He watched it with Stephanie Edwards.
Yeah.
yeah, Stephanie.
And he kept a copy. And he kept a
And
copy.
he kept a copy.
Yeah.
That's what I was about to say. He didn't supposed to have a copy of that.
So these
well, then-
copies that are popping up right now are Jim DeRogatis.
All of
Yes.
them is him, not everybody is coming from Jim DeRogatis because he's the only one that had the copy.
And
Nobody
then
else.
they're being copied and broken down into 4.
And
Yeah.
sent to
Yes.
Pennsylvania for somebody to find them in their garage while looking
Jim
for storage
DeRogatis is
windows.
behind this, y'all.
And that's why his butt is
He's the one
subpoenaed now.
He's been the one giving the copies to everybody.
Uh-huh.
He's the
And
man.
he's not going to be able to use this excuse of being a reporter because he's going to be appearing as a person, right?
He was
Right.
appearing as a person then. He couldn't
A
use it.
material witness.
That's why he played the fifth.
Kept pleading the fifth. Mm-hmm.
So he's behind this. Oh
Yep.
my God. Hold on,
Like they
y'all.
said, without the tape, it wouldn't have been no case.
You dirty dog.
Ooh, child, y'all. Child.
We mad because they didn't get him in the state.
We break the case wide open, y'all. Hold
No,
on.
he's doing this just to sell another book to say he's the reason.
He's
And
been-
look,
Yeah.
and he was
a super fan.
and he's been in conversation with Cruel Angela Cruz.
Yes.
Yep.
Oh my
He convinced her to talk to Rashonda to make Rashonda testify.
Sure did.
Yes. Hold on, y'all.
Be something else. Ooh.
Child pornography
Listen.
is such a toxic and horrible crime that to say that you had even touched that video tape, much less watched it, perhaps copied it or shown it to someone else, would be admitting a felony.
Which is what he did. He copied it and showed it to someone else. So he committed a felony, y'all.
And that's why he would not get on that stand, because he know he copied it and he was the one who gave it to all of them. And that's why they don't want him to get on it, because he's gonna have to say it.
Why is he not in jail?
Why is this dude not in jail?
Exactly.
This is what subpoena we should be. I mean, the petition we should be doing. Arrest Jim DeRogatis. He's a
Let's do that hashtag.
hashtag arrest Jim DeRogatis.
Arrest Jim DeRogatis.
And he's the one got Geronda. He's the one behind a lot of this, y'all.
He the one wrote all the lies and tried to convince all these girls to do everything. He's the one, y'all. That's why he the one convinced everybody to do everything. He's obsessed with Mr. Kelly.
Yeah, in 2017, he's the one who got all of them in it. He had Kitty Jones, he had Asante, and he had what's the other one? Cheryl Mack. He's the one that did that article. He brought them all together to come together to do this. Wow, we're busting the case wide open, people. This is why they didn't want us to read these transcripts in the public.
Yeah.
It's a time for everything, and it's the right time to read it. This is just on time, so everybody can see how everything is lining up.
Yep, and people being distracted by nonsense.
I ain't listening
Here we
to
go.
I like that campaign. Arrest DeRogatis.
The U.S. Constitution from talking about that tape. That was less than.
There it is, y'all. Arrest DeRogatis. That's why y'all need to do hashtag.
Child pornography is such a toxic and horrible crime that to say that you had even touched that video tape, much less watched it.
Good. Put that S before that T.
Or shown it to someone else would be admitting a felony. Okay? So Damon said you should take the Fifth Amendment, and, on the grounds that you saying anything at all about that tape is incriminating yourself, you're protected by the U.S. Constitution from talking about that tape. That was less than satisfactory to me.
Oh my goodness. Oh my goodness. Oh my goodness. You got to put it together with the hashtag, y'all, because it's not going to put it. Rebecca, you got to put it together. His name along with the arrest. That's that new hashtag we got to start putting up, y'all. Arrest DeRogatis. Wow, y'all. Wow. Wow. We on it. We on it, guys.
The hard part about saying arrest him is that then we would be saying that there's a tape, right? So it's like arrest him for distributing.
Ma'am.
Stop.
Mommy.
The whole point is,
Ma'am, background noise, ma'am.
the whole point is, in 2008, the judge told them that he knew that he didn't supposed to have that tape back out. He didn't supposed to have no copies. The tape was supposed to be in evidence. Okay, how did he still have a copy to spread around to everybody else?
And to reopen another case to do the same
Exactly.
double
That was
jeopardy.
supposed to be another tape out there. He was the one giving the tapes to everybody, watching the tapes and everything.
He has some fetish. I told you a fetish for Mr. Kelly. He's obsessed.
He was just jealous because he couldn't, do the things that Mr. Kelly can do. He said,
We got to find a root problem to all of this. Why he hate Mr. Kelly so much? And remember, he was in contact with Geronda. He was in contact with Azriel's father. He was in contact with Avenatti. Y'all, come on now.
We need this case to be.
Come on now. Come on.
This needs to go to
Please share this video, because I know we don't have the attendance in here, because folks don't want to know the truth. Look at the attendance. It's really not. It's terrible. We're the only one that's getting the information right now. So please share it. I'm about to get off this live. It's time for us to get off. And thank you guys. Thank you, readers. You guys did a great job today. Got some hiccups, but we're good.
You're welcome.
All right, guys. Good night, people.
Good night.
Good night. Salad.